President, please be seated. The court is now back in session. We would like now to give the floor to the lead co-lawyers if you have any objections to make regarding the documents whose identifications have been presented by the prosecutor, and if you have, please proceed.
Bonjour, Monsieur le Président.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone. Regarding the civil parties, we do not have any additional objections. However, we endorse the objections that have been made by the co-prosecutor on 4 documents by the Kyo Sampan team and 4 documents by the Nunchia team. We are of the view that these documents are not relevant. We do not have any other objections to make.
President, thank you. The floor is now given to the defense teams to respond to the objections raised by the co-prosecutor regarding some of the documents out of those 48 documents presented by the prosecutor this morning. First, Nunchia defense is given the floor. And you may also express any objections to one or several of the documents out of those 48 documents. You may also do so. You may proceed.
Thank you, Mr. President. At this point in time, we do not have any objections to make, nor do we have any comments on the objections made by the prosecution. Thank you.
Thank you. The floor then is given to Ieng Sari's defense, if you have any comment or objections to make.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom. Last week we received about a dozen email exchanges, and today it appears that the trial chamber has opted to the approach that the prosecution has suggested. We were under the impression that, one, we were to file written submissions on all of these documents, and we are prepared to do that, and we will be doing that. In other words, with each document, we will have our objection in a written form in the order in which they have been presented in the annexes. As for my oral presentation today, I will speak in broad terms because that's what I prepared to do based on my interpretation of the dozen or so email exchanges that we received. And I will limit my comments to the types of documents that are in this particular annex. And we note that there are 9 types of documents, 9 different categories. I will list them and then I will go through each one of them. And they're not necessarily in the order in which they are presented in this annex. There is an OCIJ investigative document. It's a rogatory letter completion report. There are videos. There are letters. These are in particular related to the Kyo Sampan team. Confession, Lon Norin's biography. There are some foreign government documents or reports, international communication documents, media articles, books, and academic articles. And our general comments are, and I'll go one by one, with respect to OCIJ rogatory completion reports, why is that necessary to introduce? It offers nothing. Perhaps there is a summary of a summary, but what evidentiary value does it have? Zero. The investigator can come in, or the witnesses can come in. But to have a summary of a summary come in and to present it as substantive evidence is utterly useless and has no evidentiary value, and as such, any investigative letter completion reports should be outright denied. Videos. Videos are, it doesn't matter who makes them. In this particular instance, we have one videographer who has even been celebrated around the world for having made a documentary concerning certain interviews that he did over a course of 10 years. And while we commend that as a work of art, suffice it to say, this was based on hundreds of hours of recordings, much of which was edited away in order to present the videographer's point of view and the narrative in which the narrative which they had in mind. So as a matter of principle, we would object to any videos of this nature coming in unless all the edited material be made available to the parties, all of it. In other words, this particular individual, Sambat, can produce copies of all his archives, and so we can see what exactly was left out, because there may be exculpatory information, or the material that was left out, edited away, may shed a different point of view if taken in context. The letters in support of Khieu Samphan. We, in principle, take no position. Obviously, every accused is entitled to present evidence in support of one's character. We leave it to the Khieu Samphan team to expand on why the letters are important and why they were obtained in the manner in which they were obtained, but we certainly do not object to those letters. And in fact, we wholeheartedly support their admission at this point. Confessions. Well, what can I say? We've argued this point repeatedly. And so anything that is tainted by torture should be kept out, period. Which means the fruit of the poisonous tree should also be kept out. Anything that was used from a confession should also be kept out. Long Nguyen's biography. It seems that's the only biography that we have here. Long Nguyen testified. The parties had an opportunity to question him. He indicated that he had written a biography. His oral testimony is sufficient in our point of view. If anyone wanted to use the biography at the time, they could have used it. And therefore, as a matter of principle, we see no use of it coming in at this point in time, especially since evidence was taken on that issue. Foreign government, UN, and NGO reports. Here we strongly disagree with any of such reports, no matter who tries to introduce them. Doesn't matter whether it's someone from the defense side or someone from the prosecution or civil parties. We think that all such documents, especially anything coming out of the United States and France, is suspect. More so, I would say, from the United States, since we all know they were conducting a covert, dirty war where they were carpet bombing the entire section up in the eastern part of Cambodia, while at the same time lying to the American people and lying to the U.S. Congress, and therefore anything that comes from the United States would automatically be suspect. And so therefore, as a matter of principle, we would object to those sorts of documents coming in, unless, of course, the authors can come in and can give evidence. We do not see how possibly we can accept a report from either the U.S. government or the World Health Organization when we have no ability to examine the author and to see what the sources of knowledge were in preparing the report. International communications are somewhat similar. We see some documents that were provided by the U.S. Department of State. Of course, again, I've noted how suspect we are because a great deal of disinformation was going on. Here we have some documents that were generated by the American Embassy in Bangkok. We submit that in light of what was going on at the time, one has to be very suspect as to what it was actually collected at the time and how it was put together, the narrative, that is, what was kept out for national security reasons or any other reasons. And therefore, if any such documents are to come in, then the authors should also come in to give evidence and to be examined. So we think it would be a violation of our clients' rights to have such documents coming in without any confrontation. Media articles. A newspaper article dating back either before 1975 to 1979, during that period, or after, we submit should not come in. If the author wishes to come and give evidence as to what he or she may have seen on a particular period which is relevant to the temporal jurisdiction of this tribunal, such as the fall of Phnom Penh and the evacuation period, we see no problem. We see no problem of an American journalist, a French journalist, a Cambodian journalist coming in and giving evidence. What we do object to are media articles coming in as if that is the truth, as if the narrative is indeed an accurate one, especially when the articles are likely to be used as substantive evidence. Books and academic articles, that's the last category. We withdrew documents such as books that we had initially proposed. And this trial has taken a life of its own, as any trial would, because it's an organic process. And as the trial begun and has progressed, obviously our position has somewhat shifted. But our position in general is that if a book is to be introduced, then the author ought to be here to give evidence. So, what does that mean? Kiernan is not here. He's not giving evidence. None of his books should come in. Same thing I would say for Osborne. I would say for Brinkley. I would say for anyone. No books, no academic articles, unless the individual comes to give evidence and the parties have an opportunity to examine the author, both on the sources and especially the methodology. And frankly, I think in addition to that, the trial chamber has to make very sure that before anything comes in, it has to be relevant to the temporal jurisdiction and the limited purposes of 002/01. As I've noted, Mr. President, Your Honors, we will be filing written submissions in great detail as to each document that is listed here. And as I understand, we had also had other annexes as well that we have been working on. And so we will raise our objections in writing, lest there be any misunderstanding as to what our positions are. And with that, unless there are any questions from the bench, that concludes my submissions. And thank you very much.
President, thank you, Council. We would like now to give the floor to Kyu Sampan's defense to comment or to make objections to the documents presented by the co-prosecutor. You may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. I shall not take up too much of your time on the question of the objections. I will simply recall what I said earlier, that reading your decision of the 3rd of December 2012 set out the broad lines of your decisions on the matter. I would echo the statement by my colleague concerning video materials, as we said in the first hearing on documents, and this is a point that applies to a video of Mr. Kyu Sampan that was referred to by the co-prosecutor. In this connection, I would state that if we have video extracts that were filmed by some journalist or other, we don't know, statements answering questions of which we are not aware, and we do not know where and how the video was filmed, how it was produced, in what conditions the comments were made, then there's no way you can assess the probative value of such material, and it should therefore be considered inadmissible as evidence. That's my first point. The second concerns these letters. And these, I will just recall the references of for your benefit. It's E190/2.5, it's E190/2.7, E190/2.18, E190/2.19. The co-prosecutors and the civil parties object to these letters, but they ought to be viewed within the context in which they have been put before the Chamber. And on that point, I would remind you of E9/9.2, dated 23 February 2011, in which we listed the witnesses we wanted to call. Let this be clear. The letters we are requesting to have put before the Chamber emanate from that list. And for Mrs. Claude Katz, for example, whose letter is contained in Annex 1, E223/2/1.1, whose letter itself is E190/2.19. Now that is not on our list of the 23rd of February 2011, simply because her letter arrived after that date. That's the only reason it's not on that list. Let it, however, be clear that we did submit these references that concern Mr. Kyu Sampan's testimony, but they are not ex nihilo. They concern these people's meetings with Mr. Kyu Sampan, and the context that is referred to therein is very important. We would like these people, if possible, to be called to testify before this Chamber, and indeed we believe they should testify before this Chamber. In cases where witnesses are called and all the prior documentation is required, we would therefore believe that this is part of the necessary documentation that precedes their appearance before this Chamber. Now, only remaining question is whether or not the Chamber decides to call these witnesses to testify. But as we see it, this is exculpatory material. It is part of our worries about the way in which the investigating stage was conducted, because there was not enough exculpatory evidence examined from witnesses who could provide it, and we do believe that this may be harmful to the case of Mr. Kyosompon. In other words, these individuals who have known him over the years and who are able to testify to his personality and to the context in which he was living and working. All of this is very important to us, and we ask that these individuals be called before the Chamber to testify. We know that there is a session on hearings to be conducted, and if you do not accept that all of these witnesses be called, then it is at least important that the letters be included on the case file and be put before the Chamber, because they are very important elements of information contained in them. This is an issue that concerns respect of the rights of the defence. We made it absolutely clear that we are talking both about the historical context and the personality of Kyosompon. We have not tried to deceive anybody on that issue, and the aspects of that are described by these witnesses belong to the historical context. This is something I wish to stress. I think these letters should be considered admissible. There isn't a relevancy issue here. I believe the co-prosecutor mentioned that they were not relevant, and he was wondering about precisely how the letters were obtained. Well, I think that's very easy to clarify, especially if the witnesses could be brought before this court to explain themselves. Those are the comments I would like to make, Mr. President, about the 4 objections raised by the co-prosecutors. There isn't an issue of relevance here. This chimes in very closely with the character of Mr. Kyosompon and of the historical context, because the way in which each of these people met Mr. Kyosompon is part of the whole historical context question. Thank you, Mr. President.
President, thank you. The floor is now given to the co-prosecutor to respond to the objections raised by the defense, as well as their objections or remarks regarding the objections by the co-prosecutor. You may proceed.
Thank you, Mr. President. Let me begin by answering the Yang Sari defence. The Nuncio defence did not wish to make any comments, so let me go towards the comments by Counsel Carnavas. First, we are opposed to written objections being sent into the Chamber on the 48 documents. We have a chance to discuss them now. We do not believe that things should be drawn out. Otherwise, what is the point of holding this particular hearing today? Other questions may, of course, be raised about other documents and the future of the 94 documents that we proposed additionally on the subject of forced transfer and toile boucherie. If we don't have a chance to talk about them this morning, then I imagine a decision will be taken about whether or not the defence can submit written objections to the Chamber and the parties on those documents. What I would note, however, is that as of the 23rd of November 2012, we sent in what we believed constituted the list of documents that needed to be discussed, and none of the parties on the defence side responded. No defence team wished to raise any objections or to contest the number of documents. Now I see that we are talking about future written objections, and I don't think there's any place for that. We're here to talk about it today, and we have heard a certain number of objections that were raised in extremely general terms, and the Counsel for Evidentiary pointed this out himself. But there is another difficulty. When I hear Counsel Carnivus, it seems to me as if we're going back 1 year. We talk about documents submitted between January and March 2012, but since then there have been 3 successive decisions, unless I'm mistaken, by this chamber, of which the Evidentiary defence is not taking any account. And in those decisions you can see that the objections that are raised in general terms cannot be taken forward because they have to be specific and detailed if the documents are not to be considered inadmissible. And I think that the very general terms we have heard today about the different kinds of objections that the Evidentiary defence is making need to be precise and specific for this chamber to change any of its rulings, which, except for a few exceptions, concern the documents submitted by the co-prosecutors last year. Coming into 1 or 2 points of detail, let me point out that in the list of 48 documents contained in Annex 1 E223-2-1.1, there is no rogatory letter from the investigating judges. There may be in other tables that we might discuss at a later stage, but in this particular table there is not a single one. And I read the contents of the document earlier this morning. There is one document from the investigating judges that concerns a footnote in the closing order, and it is a report, a geographic situation report on 12 Portray. Perhaps I need to point out once again that documents that have been quoted in the footnotes of the investigating judge's closing order benefit from a simple presumption of reliability, authenticity and relevance. The investigating judges have already conducted an investigation of those documents in a very meticulous way, and it, I think, indicates the need to be very specific about these objections for documents contained in those footnotes. Another ruling that the Evidentiary defence might do well to remember is decision E185, paragraphs 21 and 31, and those terms were repeated in paragraph 9 small e of the second decision on documents E185-1 of the 3rd of December 2012, and what the Chamber said there concerning a certain number of categories of documents was that no rules of procedure in force before the ECCC makes it possible to claim that the probative evidence in documents can only be produced in discussions when a witness or civil party comes to testify and can authenticate them. With respect to books, analytical documents, documentary films or press articles, these are not a category of probative evidence that should be excluded per se, on the understanding that the Chamber will adjudicate on whatever weight should be given to them. That's what the document said, and the Chamber has already said that you should not assume that any author of any book or article should have to be called before the chamber to testify for the document to be considered admissible. So I'm interested to hear the Yengsari defense saying that all of the authors of press articles and books have to testify, and he quotes the name of Osborne. Well, I would point out that it's the Yengsari defense that did propose Milton Osborne's book, E190/2.2. And contrary to the Chamber's decisions, I now hear the defence saying that if Milton Osborne doesn't come, then the defence is objecting to its own document, and consequently it can't be used before this Chamber. I'll try and be more specific about other general objections that we have heard. Let me begin with S21 confessions. I think the Chamber has been very clear on this point. So have the co-prosecutors. Everybody agrees before this Chamber that documents that emanate from torture cannot be used. But there are a certain number of authorized usage, such as confessions that were obtained in S21, and Article 15 of the Torture Convention actually provides for this, and the first document is IS 5.63, and these are Mulsambat alias Hunim's confession from S21, Northwest Secretary, dated the 14th of June 1978. And let me remind you that the Chamber itself judged all of the S21 confessions inadmissible in its decision of the 3rd of December 2012, and I refer to paragraph 17 of that decision, which itself refers to paragraph 21.9 of the Chamber's decision dated 9th of April 2012, E185. Concerning Annexes 1 to 5. The use of confessions is relatively limited. We totally agree with that by the Torture Convention, and I believe that the parties have kept in line with that practice during this trial. But I would also point out that the use that is permitted by Article 15 of the Torture Convention is firstly to demonstrate the reality of a person's detention, the reality of interrogation during such detention, or to show that torture itself has been used, or the subsequent execution of the prisoner. Within the S21 confessions, and this is not an exception here, there are annotations, and those annotations do not fall within the purview of the Torture Convention because they are written by the person conducting the torture. Second document, IS 5.63. This comes from DC CAM, and it's mentioned in the closing order footnotes, and there is a dual assumption of relevance and reliability here. That assumption is justified by the fact that the investigating judges have already assessed the reliability and authenticity of the doctor, and there is also the fact that the Chamber has already agreed that the methodology used by DC CAM is reliable, and that it is not reasonable to suspect that documents from that centre may have been falsified or tampered with. And that's the subsequent decision after actually bringing two senior members of that institution to testify here. there is S21 confession from Mulsambat alias Hunim that I mentioned. This has all of the characteristics of a statement that is considered suitable before the chamber. It includes a typewritten part and a handwritten part that is written by the interrogator of Hunim, and the document also contains the signature of Nim. Kengekyu alias Duik recognized the authenticity of the S21 confessions before this hearing, and this one is no different in its shape or form from other confessions. Finally, concerning these S21 confessions, the arrest and imprisonment of Mul Sambat alias Hunim, secretary from the northeast, is corroborated by testimony of Doik before this chamber of the 25th of November 2009, the interpreter corrects himself, in the first trial, and the transcript has this on page 55, line 22 in English, which says, and I quote, it's in English.
Lucy had been arrested. Nim too was arrested. Nim was arrested perhaps in May 1978. Nim was arrested when Mok was appointed to be the secretary of the Northwest Zone. End of quote. Donc Deutsch corrobore.
So Deutsch corroborates the fact that Hunim was arrested in May 1978. The confessions on record date 14th of June 1978, which corresponds to the same period. I will not dwell on the geographic report by the co-investigating judges. There were objections regarding various videos. I'll say a word regarding Lon Norin's biography. At the hearing of the 8th of December 2011, he discussed that biography that was presented to him by the co-prosecutors, and he authentified it. And I don't think that document poses any problem. And the reference is E3/118. It refers to transcript E1/18.1 at the beginning of the hearing, during the hearing in which that biography was presented, regarding documents that were produced by Ted Sambat from several interviews that he conducted with Nuon Chea during a period of 6 years. There are 3 documents presented by the co-prosecutors that were produced by him. We requested that that person be heard as a witness. First, we have the documentary film E186, which he produced with Robin King, Enemies of the People. Indeed, this is a film that puts together different excerpts. So it puts together a number of statements by Nuon Chea. You can argue that it is badly produced, but nevertheless, there are statements by Nuon Chea that were recorded and produced in that film. The relevance and authenticity of these interviews of Nuon Chea cannot be reasonably challenged before this chamber, in our view. Furthermore, at the hearing of the 14th of December 2011 and document E1/22.1 at 11:45 a.m., Nuon Chea admitted that he was interviewed over a period of several years by Kit Sambat. He also acknowledged that during his statements to Kit Sambat, he told the truth. That is what he states at 11:47 a.m. He said he trusted him, even though he said that he was not aware of the fact that Kit Sambat was going to produce a documentary film that would be disseminated abroad. Then Nuon Chea commented on a book that he wrote. I will return to that shortly. But that documentary film, E86.1R, and the attachments that accompany it are very important to establish the role of the accused as well as the system that was put in place during the Democratic Kampuchea regime to identify and eliminate the enemies of the regime, which was one of the policies of the party, which is the subject of this first trial. The interviews in that documentary film also concern the Democratic Kampuchea regime itself, the historical context prior to that, and the way power was organized during that regime. Furthermore, let me point out that excerpts of that documentary film have already been presented before the chamber on several occasions by civil party lawyers, and on those occasions the defense did not object to that being shown. We have a second documentary film by Kit Sambat. These are videos with the reference E93/713R and E93/7.3R. These are video clips that the co-prosecutors placed on the record at a time when they didn't have any documentary films in their entirety. These are interviews of Nuon Chea by Kit Sambat from the same series of interviews of Nuon Chea, which he did over a period of several years. So these interviews were found, and that is what is explained in the request E93 by the co-prosecutors on YouTube. The first time was in 2011 when the documentary film was not yet available. We agree that this may pose a problem of having duplicates on the record, but they are before the chamber, they are on record. So there are 3 pages of transcripts of these excerpts available on the reference E93/7.2, and that is what distinguishes those videos from the documentary films I refer to. Now, I would like to talk about the book by Kit Sambat and Gina Chun, titled Behind the Killing Fields. This document, E152.2, has been the subject of specific investigations by the co-prosecutors, E152, regarding the videos on Kil Sampan, and the chamber accepted that this be placed on record pursuant to Article 187.4. We stated at the time that that book was based on lengthy interviews granted by Nuon Chea to Kit Sambat, and this is what the authors state in the chapter at the very beginning of the book. The authors state that this book is their version of what Nuon Chea said, and it's based on over 1,000 hours of interviews conducted over 6 years. This book essentially contains quotations made by Nuon Chea, meetings with Nuon Chea, adopting his point of view from the years when he was on the ground up until the period of Democratic Kampuchea, regarding Nuon Chea's statements regarding the historical context and the role of the accused before, during, and after the period from 1975 to 1979 regarding the structure of the regime, the policies of the Democratic Kampuchea government, including the forced transfer policies, the transfers of civilian populations. This book is very important. It should be admitted by the Chamber. It is in line with the case law of the court. And as I stated earlier, the authors of this book do not have to appear as witnesses in order for this book to be admitted into evidence. That said, we requested that the author of this documentary film be called as a witness. Something that would enable us to resolve a question regarding this book. It is the issue: who is truly the author of this book? In the hearing of the 14th of December 2011, the transcript E1/22.1 at 12 noon, Nguyen Chia stated the following, which establishes the reliability of the book. He stated, and I quote, "I wrote a biography. I asked Ted Sambat to publish this book, this biography in Cambodia. He said he would prefer to publish it in New York because Cambodians did not like to read very much." And further on, he states, "I authorized him to do so. I wrote on the history of the regime, and Ted Sambat translated that into English." End of quote. He subsequently complains that this book was published without his approval. Be that as it may, this publication shows the close link he had with this book and Ted Sambat, as well as biographies written by Nguyen Chia. In this regard, with a view to bringing the truth to light, this book should be admitted and placed on record, independently of whether the author of the book appears before this chamber or not. Let me turn to the statements by Khieu Samphan's defense. He talked about the 53 long interviews of Khieu Samphan. She stated that they didn't have the name of the journalist, nor the questions, nor the circumstances surrounding the video. It's not completely untrue, but the conclusions drawn by Khieu Samphan's counsel focus on the probative value of those interviews and not on the issue of admissibility. Now, we are talking of 53 videos. The references are E152.1.1R up to E152.1.54R, as well as all the transcripts of those interviews. That is E152.1.1 and E152.1.54.1. So these are 53 videos of long interviews that last 8 hours, more than 8 hours. And Khieu Samphan is the only person who appears on the screen throughout those long hours. It would appear that the videos were done over 2 days. And these 53 videos were classified under one column. And the co-prosecutors gave a number of explanations in the motion E152 of the these excerpts of videos have to do with the historical context of democratic Kampuchea, the role and responsibility of the accused, the structure of the regime, and the various policies, including population transfers. We do not know, indeed, who is the journalist asking the questions, but we hear a voice, the voice of someone asking questions. Contrary to what the defense has said. However, that person is not identified. But the fact is, it is Kyo Sampan who is being questioned, and we cannot imagine that this is a forgery or trafficked video. We request that the transcripts of this video should be tendered into evidence. Regarding the letters and testimonies produced, we've heard the position of Kyo Sampan's counsel, who reiterates a request that those persons be called before this chamber. And this is not in line with the arguments I raised earlier. But the chamber should clarify under what conditions the counsel for the accused can contact witnesses. I have no further arguments to raise in support of my objections, Mr. President.
The President, I hand over to the lead co-lawyer for the civil parties first, because that will be in addition to the objection as well as the response by the prosecution to the objection by the defense counsel. Lawyer Pich-ong. Good morning, Mr. President. Good morning, Your Honors. I am representing the civil parties. I would like to raise a few points in relation to the objection by counsel Kanavas and lawyer for Kyo Sampan in relation to document 11, which concerns the video document, and my esteemed colleague Simon O'Fort will provide additional arguments because the documents that have been put before the chamber now, the video that lasts for several hours, and we do not know whether or not the question will be corresponding to the answer, and we do not know under what conditions the video were produced. If we look at the basis of the objections, we do not see any rational grounds, or in other words, there is no sufficient grounds in order to indicate to the court that the videos were done under exceptional circumstances. And if we look at these videos, it depicts the activities of the accused Nguyen Chi and Kyo Sampan, who at that time had full freedom to speak in the region where he was residing at that time, and the video were taken over there as well. So we believe that this can be the reliable evidence. And in addition, since this video describes the activities of the co-accused, namely the activities that the accused were describing of the event that unfolded in the within the temporal jurisdiction of the Khmer Rouge Tribunal, and this is indeed relevant to this particular segment of trial, and that should be put before the chamber. And I believe that these evidentiary documents can be used before this court, and I fully support the argument raised by the prosecution concerning the specificity as well as the relevance of these documents. Thank you, Mr. President. The President. Thank you, and the international lead co-lawyer, you may proceed.
Je voudrais simplement ajouter quelques...
I would like to say a few words in addition to what has been said regarding the request made by the defense today. We do not quite understand the attitude of the defense today. I am asking questions as to their objectives because in late 2011, Defense Counsel were given the opportunity to make all objections they had on documents proposed by the parties. Those written objections were made, and there were 3 oral decisions, and the Defense Counsel were invited to make any objections and any others they had, and 2 decisions were taken by the Chamber, E1885 and E1851. In those decisions, all the objections raised by the defense were addressed. Let me take just 2 examples which were referred to by the prosecutor as well. Let me take paragraph 21(5) of E185, which clearly addresses the general objection to books, documentary films, and media articles. And the second example is the example relating to the fact that there is no absolute right to confrontation with the author. So the Chamber has already addressed a large number of objections today. On the list of 48 documents drawn up by the prosecutors, I hear exactly the same objections that were raised before and which the Chamber responded to. Let me note, by the way, that on this list of 48 documents, there are only 11 documents presented by the prosecutors and civil party lawyers, and the defense is making the same objections to these 11 documents as they did before. So the civil parties would wish that, on the one hand, the Chamber should reject these general objections, in respect of which the Chamber has already responded. And the civil parties also request that the Chamber should, in particular, not authorize any written objections, because this hearing is for objections. And if we continue to meet to hold hearings on objections, and again new hearings for objections on top of written objections, which are always the same, would be wasting the court's time. This is the position of the civil party lawyers. Thank you.
The President, thank you. In the interest of time, we have only a few minutes left before lunch, and I noted that the International Defense Counsel for Mr. Kyu Sampon were on her feet just now, and if you had any observation to make, you may proceed.
Mr. President, before Counsel for Kyu Sampon proceeds, let me just make some brief observations. In the past, we have filed written objections. We don't try to go out of our way to create extra work for ourselves. We have better things to do than to spend the weekends trying to figure out what documents to object to. So if we were to, if the trial chamber were to provide us with some clear guidelines, what it expects from the parties, we will do so. But in the past, we have filed written objections, and I don't understand why the prosecutor is getting all worked up, because that has been the procedure. So give me a procedure, and I'll follow it. But that's the procedure that we've used in the past. The prosecution also was dumbfounded why I mentioned Osborne. Let me be very clear. We've indicated that we withdrew documents, and we're taking a principled position as we have in the past. So there is no dilemma, and there's no need to try to create some kind of an atmosphere that somehow we don't know what we are doing. We submit, Mr. President, that these oral hearings are for the benefit of the public so that they know exactly what sort of documents we are dealing with. That was my understanding. We would give brief explanations. But as far as detailed explanations, they would be provided in writing. Now, if the trial chamber wants it otherwise, please provide us with clear, unequivocal language, and we will follow it. But we are doing what we think was expected of us. And if we got it wrong, then we apologize. But certainly, we spend the entire weekend working on all sorts of documents, preparing answers to every single one that has been presented here. And there are more than one annex. While at the same time preparing for witnesses, where the list is being changing, and at the same time, now that we are preparing also an appeal before the Supreme Court based on your recent decision. So we are not looking for work. Just provide us with some clear guidance. Thank you.
President, thank you. In International Counsel for Mr. Kiew Samphan, you may proceed.
Merci, Monsieur.
Thank you, Mr. President. I will try to be very brief. Let me make an initial point regarding the issue raised by both the co-prosecutor and the civil party lawyers, in respect of which my learned counsel has just reacted. Let me refer to your memo of the 16th of January 2013, E158, regarding the specific circumstances of this hearing, namely the admission of Mr. Nguyen Chia and Mr. Kiew Samphan to hospital. Let me repeat, since I am told that I am speaking too fast, I'll try to slow down. Regarding your memo, E258 of the 16th of January 2013, you pointed out that even if a client exceptionally waives his right to be here during this hearing, let me quote in English.
To make additional submissions on documents following letter consultation with our clients, if so requested. Fin de citation.
End of quote. I clearly pointed out at the beginning of this hearing that not only did we not have enough time to ascertain whether the 48 documents referred to by the prosecutor were the only documents that call for discussions today, but it is clear that Kiew Samphan's health status did not enable us to have in-depth work on these documents with him. Under these conditions, I therefore do not understand why the co-prosecutor and the civil parties want the debate to be clinched, whereas you are opening the door to the possibility of entertaining further remarks. I want this to be clear for the record.
The President. Thank you. The time is now appropriate for adjournment for lunch until 1:30 this afternoon. The court is now adjourned.